This morning, I'm really excited to say that we have two prominent employment attorneys, Alexis James and Renee N, on the line with us. And they're going to do a presentation on how to stay out of hot water, the 10 most common mistakes employers make with respect to human resources. And I'm going to let Renee and Alexis introduce themselves. But the only thing I'll say is they spent 10 years as plaintiff's attorneys working with employees that were having issues with their employer. And now they're on the other side representing employers, and they have a wealth of information. So, Renee, are you there?
Yeah, can you hear me, Barry?
I can hear you, so it's all yours. I'm going to put myself on mute, and you can take it away.
Okay, hi everyone. As Barry introduced us, I'm Renee N, and my partner here is Alexis James, sitting next to me.
Good morning.
So as Barry said, Alexis and I were both plaintiffs' attorneys for over 10 years. And for what we did as plaintiffs' attorneys, we represented employees suing companies. And we sued a lot of very large companies for different employment issues. And what we noticed by suing these companies that had every resource available to them, from in-house legal departments to huge human resource departments, office managers, every resource you can possibly imagine, still they would make the same mistakes over and over again, which would get them in really hot water, and they'd be in litigation, which is extremely costly, as everybody knows. And so when we started our law firm, WorkWise Law, we decided that we were going to help companies, and particularly small and medium companies that don't have these huge resources that the larger companies have, to help them prevent the mistakes that the larger companies keep making that are getting them sued. So we started this law firm advising and guiding companies and helping them figure out how to handle their employees and how to figure out what they're doing on a day-to-day basis to prevent their exposure and potential liability. So that's who we are, and that's what we've been doing. And so we put this presentation together of the top 10 common mistakes that employers are making. And so hopefully you guys will get something out of this so that you don't make those same mistakes and you don't find yourself in court.
Okay, so the first mistake that we're going to talk about, let me change the slide here, sorry. Okay, is failing to address employee complaints properly. And while this may seem common sense, tone is really important. And I think that employers forget that employees that are coming forward with a complaint already have a distrust of management or the employer taking their complaint seriously. And that distrust can lead to an escalation of a problem. So employees complain about everything from the air conditioner to the state of the office fridge to the more serious issues concerning favoritism or the need for a medical accommodation. And how the employer reacts to these complaints is critical in ensuring that the problem does not escalate. So employers need to act promptly when an employee comes forward with a complaint and schedule a time to talk. We recommend that that meeting should take place within 24 hours, and that the employer starts with a feeling of being open and not being defensive, treating the complaint seriously and being sincere. And the reason why we had so many plaintiffs come to our offices is that employers who heard their complaints never got back to them with a plan of action or a response that they had looked into their concern. If the employer just felt that the concern really wasn't worthy of investigating, or that they just dismissed the employee outright, it just quickly led to the employee running to the plaintiff's attorney, who is going to be empathetic and listen and take their concern seriously. So remember to thank the employee, reassure them that they did the right thing by coming forward with their concern, and come back to them with a plan of action of how you are going to look into their complaint, what conclusion you've come up with. This is not to say that we recommend that you agree with every suggestion that the employee makes. Obviously, you have your own concerns and legal and fiscal responsibilities. But if you hear the employee out, if you look into it, if you get back to them with feedback, it makes them feel validated and more trusting of the complaint process.
Okay, the next mistake that we see happening over and over again is having inconsistent corrective action. So it's very, very important that you train your supervisors and managers to apply workplace policies fairly and consistently to all of the employees. So regardless of race, sexuality, gender, color, religion, all of the protected classes, and also regardless of how the employees perform in their jobs. All the policies in your office have to apply exactly the same way to every single employee. Inconsistent application of workplace policy can be circumstantial evidence in court of discrimination, regardless of the actual reason as to why the policies are being applied differently to different employees. So one of the ways to do this is your performance evaluations, because just to give a little bit of background, whenever there's and this is an obvious broad generalization, but when there's an employment lawsuit, the employer is always going to say that the employee had performance issues. And the employee is mostly going to say that the employer discriminated against them. And the first thing that you do is you look at the performance evaluations. This is the plaintiff's attorney I'm talking about. We'll look at that to see, well, were these really performance issues? Are these legitimate? Well, 9 times out of 10, if not more, the performance evaluations will show that this employee is a stellar employee, and it's going to all, exceed expectations, meet expectations. They're, if it's judged out of 5, they're going to get 4s and 5s. I mean, this is a theme in employment lawsuits where you look at these performance evaluations and they're really, really good. So then you just, shot holes in the defense attorney's case to show that, that it's not a performance issue. In fact, it probably is some pretext or discriminatory reason that they were terminated. So what we say now, working at, on the defense side and helping companies is you need to be honest in your performance evaluations, and you need to be able to be, if there's any weaknesses, you need to be able to have that reflected in the actual evaluation. So, if there are performance problems, even if it's not the evaluation itself, you need to make that known to them. It needs to be written down, documented. Don't try to be so nice to your employees by, not feeling like you can be honest about that.
And just to point on that, it doesn't always have to be a formal evaluation. What we've heard a lot of people talk about is the millennial generation needing instant feedback. So having a yearly performance evaluation for them is almost meaningless because it's way beyond the time that they did a project and they want feedback. So remember to document, even informally in an email, the feedback that you're giving them, the performance metrics that you want them to be judged by, and keep that in their file as evidence of how they are performing. Okay, so this is a broad mistake. Obviously, not understanding the state and federal law requirements is a huge topic. But what we find with the smaller companies is that they are winging things. They're just too busy in handling all the various aspects of the job, marketing and IT and, the requirements of each individual job, to have someone that understands all of the state and federal law requirements. And in California, ignorance is bliss. There are so many requirements that you have to uphold. And just like Barry said in the introduction, missing one item on a paycheck can result in a $1.2 million settlement. And small businesses can go under very quickly by making these easy mistakes. So the first thing to do is to have a legally drafted employee handbook and to have it updated every year. So many of our clients, when they first got into business, got a simple employee handbook, maybe through ADP or Paychex, and they have not taken the time to update that handbook. And again, this is going to be used as evidence when a lawsuit is brought as to, what are the policies and procedures? Are they compliant? And do your employees know about those updates? So make sure that you review your handbook. You also need to know things like what types of disclosures you have to give at time of hire, what items need to be on the pay stubs, what entitlements your employees get with regard to sick time, final pay. I mean, there's so many intricate laws about how payments are made and within what set of hours. You really need someone to be on top of that. So it's a good idea, as you're doing with really great employee benefits here, going through educational series and making sure that you're staying on top of those rules.
Okay, misclassification is a very, very big topic. And especially now, the IRS is really cracking down on this specific topic. And so it's a mistake that you want to be aware of. So many businesses, understandably, it's so expensive to run a business, especially in the state of California. So they're attempting to avoid very significant tax and other liabilities by classifying workers as independent contractors instead of employees. But the problem is, and we tell our clients all the time, is the improper classification of those workers can result in such steep penalties. It makes more sense to just pay the proper taxes. It'll cost you less in the long run, guaranteed. If you get caught improperly misclassifying, it's really very terrifying penalties that will be imposed upon you. There are several tests that are used to determine whether an independent contractor is properly classified. I'm not going to go into all of the details because I could do an entire hour conversation just about that. But the main theme here is it's all about control. So the more control that the employer has over the worker, for example, their hours, the location of where the worker has to perform the job, whether or not there's specialized skills, special licenses, things like that, this all plays into it. Classification lawsuits are very expensive to defend, and they can disrupt or even destroy a company's business. If you know, and even if you believe that you're using the the independent contractor classification properly, it's a very wise idea to have an attorney look at that, because oftentimes, you know, we've had clients that are adamant that these are true independent contractors, and we see it differently, and it's not black and white. It's a very gray area.
And employers can help themselves with their job descriptions. You know, if there's a gray area between an independent contractor and an employee, an attorney can help you draft a job description that will help support that classification. So it's a good idea to review those and update them. You know, as you give an exempt employee more independent judgment, then your job description should certainly reflect that, and it will help support if you ever have to defend yourself in a classification lawsuit.
Which is a very good point that Alexis is making, because so many of our clients don't have job descriptions at all, which is very, I mean, they don't have, most don't have employee handbooks that are current, and job descriptions, which are two very basic levels of protection that you should absolutely have. So the other type of classification that becomes a problem is exempt versus non-exempt. So an exempt employee, all that means is they're exempt from overtime pay, the meals and rest period requirements, if there's uniform requirements, and other protections from the Industrial Welfare Commission orders. So there's a California labor code out there that requires that exempt workers earn typically a salary equal to 2 times the minimum wage. They also have to fall into one of 3 exemptions. It's a executive, administrative, and professional exemption. And within those are also a ton of laws and rules, and it's very, very dense and it's actually not that complicated, but it just requires a lot of time. So I'm not going to go into that either. But there are rules regarding this, and if you're gonna put somebody on salary and hope that they're just an exempt employee because they're on salary, it doesn't always work like that. And you can, again, get yourself into a lot of trouble. These wage and hour lawsuits are coming up left and right, and they're very expensive to defend. And the penalties that are imposed, again, just like with an independent contractor situation, they're really significant. So it's something to definitely take a look at.
Okay, so the next mistake that people make is with overtime. Employers obviously get into problems when they are winging their procedures for paying overtime, or when they try to compensate through time as opposed to money. There's a lot of mistakes that can be made in this area. So just as a brief overview, overtime needs to be paid if an employee works more than 8 hours in one day at the rate of 1.5 times their pay, and more than 12 hours would be 2 times their pay. There are a few limited exceptions depending on the type of industry, but in general, those rules apply. And in California, salaried workers earning less than 41,600 are eligible for overtime. An employee who fails to pay for overtime is liable for wages due and civil penalties. It is okay to compensate an employee with time off for overtime, but it must be time off at time and a half. So it's either money time and a half or time off. And there was just a recent Supreme Court case that changed the calculation of how overtime is paid as it relates to bonus payments. They have changed that method for calculation. So if that applies to you, we'd certainly want to revisit the base pay that is calculated when the bonus gets factored into it.
Okay, and then along the same lines, we're talking about breaks. Unless there's an exception that exists under a statute, which is usually a union situation if there's a collective bargaining agreement, other than that, for most jobs out there, employers have to provide a non-exempt employee who works at least 5 hours in a day with a meal period of at least 30 minutes long. And that is, you don't have to pay them for that time, but you have to provide them that time to take a break. If an employee's total work period does not exceed 6 hours, then you can waive the meal period through mutual consent. An employer has to provide a second meal period at least 30 minutes long if an employee works more than 10 hours a day. But again, this is just for non-exempt employees. They can waive that second meal period again by mutual consent if only the first meal period is not waived, and if the total hours worked is no more than 12 hours. So this is like very, very rule intensive. But it's really important to know that because, again, this goes into wage and hour lawsuits if it's not complied with perfectly. An employer's duty to provide a meal period means that the employer must make that time period available to them, but they don't have to police the meal period. So you can still require them if they are doing work, that's not going to be detrimental to you, but you can't ask them to do it. You have to give them that time to be able to eat, do whatever they want. The rest periods, there's a lot more detail about this, but just for the interest of time, the rest periods are a little bit different because a rest period is based on the total hours worked daily, and it has to be at least 10 minutes long for every 4-hour work period or a major fraction of this work period. So what's so interesting about the rest period, and I'll just kind of go into the interesting part of this, is that it's very protective. The California law is very protective of the employees being able to get those rest periods. There was actually a California Supreme Court case that said that the employers have to relieve employees of all their duties. If you have an employee and you're saying to them, you know what?
We just lost you.
Can you hear me?
Yeah, why don't you repeat what you just said? We lost you for a second. I don't know if you're speaking away from the microphone or not, but we just lost what you said.
Is that better?
Much better.
Okay. Sorry about that. So the interesting part about a rest period is how protective California is, that you cannot require your employees to do any work whatsoever during those 10-minute breaks. And you can tell them that they have to stay on the premises since it's such a short amount of time, but you can't give them a single job duty during those 10 minutes. Just by way of example, there was a California Supreme Court case in 2016. And in that case, it was security guards, and a bunch of the security guards were working for this one company, and they were told, okay, take your 10-minute break, it's fine, but keep your radios on in case there's an emergency. Well, because of there's that one requirement that they had to keep their radios on, they went to court. They came together, found out that there's a potential lawsuit there, and this lawsuit ended up settling for $90 million, which is outrageous. But the point of this is just let them have their break. Don't ask them to do a single thing, and then you'll be in good shape.
Okay. And also with your time system, something that we've been recommending is on each pay stub or method of validating your time, have the employee sign something that states, I have been given all of my required rest breaks and lunch periods, or if not, I have, this complaint to allege. Because if you have a record that this employee every single week that they've been employed by you has signed off that yes, they've been given their required lunch periods, that's going to be strong evidence for you if they later, 3 years down the line come back and say, I've never had a lunch in my entire career at this company.
Okay, so now we're going to talk about improper response to sexual harassment complaints. So in light of the Me Too movement, which I'm sure you have all heard about in news, and because of the public opinion that has now shifted to now believing accusers so strongly, employers are now starting on the defensive. That's the beginning part of the story. It's just they have to be on the defensive. And so to overcome claims for sexual harassment, employers need to be very, very proactive in how they're creating respectful office cultures, training their management, and responding to claims. The biggest problem as far as sexual harassment goes is when an employee complains that they're being sexually harassed and the employer just dismisses the complaint as, oh, that's just Ben, he's a hugger. There was a recent case that actually came down holding that hugging formed the basis of a sexual harassment complaint if it's constant and if it's unwelcome. We're not suggesting that you never hug any of your employees. You just need to be aware of these rules and the climate in which we're all living in, especially right now. So the first thing, if you get a sexual harassment complaint, the first thing that you need to do is to separate as much as you can the victim and the alleged harasser. So it means physically separate them into different parts of the office if you can, and take the victim employee out of the chain of command of the alleged harasser. The victim should not have to answer to the harasser at all. Be aware that all companies with 50 or more employees are required by California law to get sexual harassment training for all of the supervisors and managers every other year. Although now with what's going on in the world and all of the lawsuits that are coming down and the public opinion, we're recommending even to our small businesses of even, you need one employee to get a sexual harassment complaint lodged against you. So even the smallest of small companies, they still should be doing the proper trainings and be proactive in this area.
One second, Renee, can you just, before you guys move on to the next slide, two things I wanted to point out. One is we're partnered with Think HR, and they have a great online sexual harassment discrimination training that employees can take online and get a certificate. And then the second thing I wanted to mention was I recently learned of an HR consulting firm that has an employee hotline for harassment. And there's 140 companies around the country that use it so that an employee can make a complaint anonymously or with their name, but to an 800 number, so they don't have to go into their own company, especially if it's a smaller company, and talk to HR or talk to management, and they're sometimes afraid to do that. And so there's this hotline, and I thought it was a great idea, and the hotline's been around for a while. But just learning that because of this Me Too movement and what's happening, that employers really have to be careful and have areas to protect those employees that are claiming discrimination. And one final point, we did a seminar a few months ago about EEOC and Department of Fair Employment and Housing complaints, and the number one complaint they get are discrimination and harassment complaints. And there was over 20,000 complaints last year, and the complaints in the harassment area were over 12,000. So I just wanted to point that out, and then Renee, go ahead from there. I'm sorry to interrupt.
Okay, no, that's fine. Actually, Melody, I see a question for you. Did you say employees needed to be trained annually and managers every other year? It's supervisors and managers that have to be trained every other year. But again, the employees, it's not required that they be trained, but just to help the climate of the company, it's definitely advisable to have, if you can do a training with all the employees there, all the supervisors, managers, more often than every other year, ideally every single year. There's no wrong reason, or there's absolutely zero negative to doing that, to being more proactive.
And you can also do it less formally than a AB 1825, compliant training in your safety meetings or in your monthly meetings. Just bring up the company's harassment policy, and again, the managers have to model what the proper conduct is. So it's good to have reminders, and also to let the employees know that the company has a mechanism in place. You were saying that there's an anonymous phone call system, that HR company can bring up. That's a good idea. However, some employees will often say to their HR managers, I don't want to get this person in trouble. I don't really want to come forward with it. That does not take the employer off the hook of doing their investigation and making sure that there's no further harassment going on. So even though the employee might be reticent to bring forward the complaint, that doesn't mean that the employer can say, well, they didn't want to go forward, so we didn't do anything about it.
If I could just step in, there was one more question from Lorena regarding meal periods. And the question was, if we shut down the plant at lunch, do employees still, or should they be required to clock out? We have all the employees stop production and go to lunch at the same time, but we don't have them clock out.
A record should always reflect the periods that are being worked and not worked. And on that point, you know, an employer can require their employees to stay on the premises during rest breaks, but they can't require them to stay on the premises for lunch. So it sounds in this case like you shut down the plant for lunch, that the employees can go elsewhere. But for the rest breaks, you can require them to stay on the premises.
But I think it's advisable that especially if you have a larger company, if there's a plant and there's many employees, to have that written documentation to show that they actually did take their lunch break, they clocked in, they clocked out. It's just going to help you we think we're attorneys, so we think in lawsuit terms. And so if there's a lawsuit and there's any argument about that they didn't get the proper lunch break, then at least you have that documentation to show that they did. So it's, again, you know, we're all about layers of protection. That's kind of our theme in our office. So it's just an added layer.
And it's better if the individual employee, you know, marks off their time as opposed to a shift manager. We were working with a construction company where the shift manager just wrote that everybody got their lunch at 12, and it was just like a one check for the whole company. And that, you know, did not hold up well when challenged that the employees got their breaks, because it just looks like the HR manager, or sorry, the shift manager was just, you know, complying for the sake of complying, but there wasn't really a truthfulness to it. So if you can implement the employees having the power to work off their time, that's a good idea.
And let me add, and it's kind of ironic, but there's a company called Timely Industries in Pacoima that had a PAGA lawsuit all about lunch hours. They would shut down their plant at lunch every day, and everyone would have lunch at the same time. And one employee got bent out of shape and sued, and they had to settle for $1.3 million. And so, you know, number one, as Alexis and Renee said earlier, it's good to have people sign off on their timesheets and acknowledge that they receive their appropriate lunch periods and rest periods.
All right, we're almost at the end here. Just have a few more mistakes that companies make.
Okay, so this is from the beginning. Employers get themselves into trouble by not doing their due diligence when they're hiring. And there have been so many lawsuits that we've been involved in where, you know, a background check wasn't done and the employer didn't know that an employee who is responsible for finances, for example, had a embezzlement claim in their past. We had another employee who represented he had worked for a company for 3 years. In actuality, he had worked there for 6 months. You know, you have to do your due diligence in making sure that what's on the resume is accurate. And, you know, there's a lot of laws, especially recently, about what types of information you can ask in your hiring process. So it's important to review those practices. You can't ask about prior salary, for example. You know, yesterday was Equal Pay Act Day, and that's a real focus in California, is trying to get rid of gender disparity in pay by asking about previous salary. But you do want to do the proper disclosures at hiring. You want to get to know your candidates. You want to verify the information that they're giving to you in your employment application. So make sure that you do thorough interviews and that you know what questions you can and can't ask in those interviews so that you don't expose your company to liability.
Okay, so the next mistake that is made constantly in employment lawsuits is the interactive process. Interactive process, all that means, it's a very fancy terminology for the word, for the meaning of conversation. It's just conversation between the employer and the employee. If you have an employee that's going out, even while they're out on medical leave, you need to be constantly engaged with them. You need to initiate, as the employer, it's your duty, your legal duty, obligation to initiate this conversation and make sure that you are trying to get them back into your company if that's possible. So that means you need to talk to the employee, figure out where they're at. You need to look at their medical record, the doctor's statement saying what their medical restrictions are, what they can do, what they can't do. You need to compare that to what is on their essential duties. Again, is another reason why it's so important to have job descriptions. You need to figure out how you can fit them back into the company. The larger the company and the more different types of jobs that exist for the company, then you're going to have a bigger duty to try to get them to be able to work there. So often companies, they feel like they say to their employees, come back when you're 100%, which you're not allowed to say. You have to try to work with them as soon as the doctor releases them and they're ready to come back to work. You have to try to get them back in there. And even if, and this is what we have seen a lot on the guiding and advising part of this job, is so many times we have employers call us and they say, you know what, this employee's out on medical. They have so many issues, so many problems for the last 2 years. Like, we just need to get rid of them. Like, there's probably nowhere for them to come back into, and we don't want them anyway. They were not a good fit. And that is like the worst thing you could do, is terminate an employee when they're out on medical, even if you can absolutely definitively prove that it's performance issues and that's why you're trying to get rid of them. As soon as you have this medical status out there, you're walking yourself into a strong disability discrimination lawsuit that a plaintiff's attorney will be very, very happy to start. So you have to be very aware of that and do the interact process. And if there are circumstances where there is nowhere to fit them in, but you really need to make sure and do your due diligence, bring an attorney in to facilitate the interactive process, to make sure you're doing it properly, and recognize that it's not just one meeting. It's an ongoing obligation that you have to continuously be on top of.
And just on that point, with our smaller clients that have workers' comp claims that are brought against, I think that there's a feeling of it being personal. How could this person file this claim and it's going to cost me $22,000 and it's really going to affect my bottom line? And so that creates a bad feeling towards that employee. And if the employer acts on that feeling, they're just opening up a can of worms of creating, potential liability. So even if you have to fake it and make sure that your employee believes that you're doing everything that you can to get them back to work, you have to put on that face and go through the process and do it properly and make sure that the employee is given the opportunities for accommodation that they are legally entitled to.
Okay, we are on the last mistake that employers make.
Okay, so not terminating a problem employee. Again, it's really difficult to terminate someone and to feel like you're affecting their livelihood. We've had many employers who noticed red flags in the probationary period and just kept telling themselves that they could change the employee, that they could get them to act to their expectations. And so a problem employee in the first 3 months is suddenly with the company for 2 years, and then you want to terminate and you haven't documented their performance issues all along, and then suddenly sue you for discrimination for some protected class. So it's important to clean house of your toxic employees and to really evaluate them at the beginning and see who does have potential and who is just going to be a problem employee who's going to take your time and money in dealing with them and creating problems down in the future. So document everything. Again, this goes back to Renee's point of having honest performance evaluations and setting metrics that employees either have to live up to and that they understand everyone is being treated equally and of those metrics. Otherwise, it's time to clean house and move on to an employee who's going to better fit your goals.
So those are the 10 most common mistakes. There's obviously many more mistakes that companies tend to make, but these are just the ones that we put into our presentation. But if you have any questions, about any of this, you know where to find us, or hopefully Barry will make it clear where to find us. And we really want to thank Barry for giving us this opportunity. Really great Employee Benefits is a wonderful benefits company that offers so much more than just that. And I love that you do these webinar series and give your clients information, which is really useful and helpful, and we're happy to be a part of this. So thank you, Barry.
Thank you. Let me just add on that last slide that We have a client in Glendale that had an employee that was 75 years old, and they wanted to terminate them. And immediately I said, you really need to speak to a labor attorney, because my first question was, do you have any performance reviews? And the answer was, no, we've never done a performance review. So they had no documentation whatsoever, and I introduced the president of this company to Renee, and she was able to help them out. But too often we see no documentation and then wanting to get rid of somebody. So having said that, if anybody has any questions, feel free to type the questions in. As a reminder, Renee and Alexis are with WorkWise Law, and that's their contact information. Next month, two things. One, we're having this webinar on PAGA. I believe it's the second Wednesday or third Wednesday of the month. It's probably second Wednesday of the month. We'll get invitations out. Also, Renee and Alexis spoke a little bit about non-exempt and exempt in 1099. We had a webinar last year, about a year ago on that, and if anyone is interested in getting a copy of that PowerPoint or the recorded webinar, let me know, and I'll get it to you. But we see this all the time. Peter in my office was calling on an architectural firm where the architect said, I have 9 architects and they're all 1099. And immediately Peter, goes this cringe in his stomach, because it's impossible that these architects that report to the guy are 1099. That's the first gut reaction. And the second is, are they independent architects that have their own business and they just work for you? And he goes, oh, they just work for me. So he had an issue there, and he didn't even know about it. There's a question from Eric. You use the term probationary period. We carefully avoid any talk of this, as it could be inferred that after the period is over, that there's an implied contract of continued employment. Are we being too careful? I'll let Renee and Alexis handle that.
That's a great question, Eric, and we just dealt with this with another client of ours. It's really important that your offer letter and your employee handbook talk about their employment being at will at all times. And if you are going to use a probationary period, that you specify, even though you will be evaluated during this 90-day probationary period, that is not a guarantee of continued employment or even continued employment during the probationary period. You could have an employee for 5 days who's doing everything wrong, and you want to get rid of them before the 90-day period. So I think you're right to be careful about it, but the best thing to do is to cover yourself with documentation specifying that the at-will status of their employment starts from day one.
Let me add one other thing. If you look at HR literature around the country, the term probationary period has gone out of style, because probation sounds like they did something wrong, and all they did was get hired. And now that word becomes introductory period. So a lot of handbooks now say introductory period rather than probationary period. It's the same kind of concept. The first 90 days, it's like we're looking at them and they're looking at us and what have you. But that might be another thing to think about. Any other questions? Well, seeing none, I want to thank Alexis and Renee for a great webinar on these 10 items, and recognizing that we appreciate all the people that are in attendance. As always, we've recorded it. We will send you out a recording and the slide deck in the next week, and we'll be posting the recorded webinar on our exclusive Renee, really great employee benefits YouTube channel, where all our prior webinars are too. So having said that, thanks again, and we'll see you next month.
Thank you.
Thanks so much.